miscellaneous docket. We'll begin with Mr. Cotton.
Good morning, Your Honor.
Good morning, Mr. Cotton.
Good morning, Your Honor. Byron Cotton for the record, present with Anthony Knutson. Judge, we're here on a motion to reinstate the set bond on original charge in this case. The original charge in this case was a grand theft charge of a motor vehicle. The allegations are that my client took his mother's car and would not return it. Obviously, there's some factual issues with powers of attorney and all in play in that. The basis of the violation is that there was separately an injunction in place.
Was it what kind of injunction?
Domestic violence.
Stay away order on the criminal. I was a little unclear because it said new charges of contempt, and I couldn't find.
No,
I couldn't find the case number.
It wasn't a violation of. There was no stay away order that I'm aware of on the grand theft charge. It was a separate injunction based on circumstances.
Like a domestic violence injunction.
There was no allegation. It was allegations of a threat. It was civil. Yes, sir.
Civil injunction.
Yes, sir.
That's correct, Judge. This stems from a family dispute where the defendant allegedly took some $200,000 from his mother and stole her vehicle, amongst other things. So there was an injunction against the defendant by the victim in this case, who is his mother, and she is present today.
Okay.
There was a guardianship. Cash has been returned to the guardianship. I assume been returned to her at this point from that allegation. When I say a guardianship, there was a petition, Judge. The guardianship ultimately was dissolved. There's a lot going on in this. We're here today. The violation is for text messages purportedly.
It's all kind of interrelated, though. So
They are, Judge. They are, Judge, and that's why I'm letting the court know about
sure.
it. Your Honor, the specific allegation that is the violation is a new criminal offense based for a violation of the civil injunction for a threatening text message sent by his girlfriend, purportedly at his request, to his mother about his brother. That is what the new law offense is, and that was the basis of the revocation of the bond in this case. We're asking the court to reinstate the bond or set a bond in this case with reasonable assurance. Since this time, guardianship's been resolved. Parties have been to an injunction, stipulated to a 2-year injunction under the civil injunction. I think that was done August 31st, so subsequent to this. The injunction went into place, I believe it was filed for March 20th, served March 21st. This allegation was from June 11th. This text message was purportedly sent, at least based on the allegations in the arrest report, from June 11th to August, I believe it was 31st or 20. When were you arrested? 17th. My client, there's been no purported violations of the injunction for that 2-month period, so this was an isolated incident. 3 months after the injunction, by someone else, purportedly at his direction, and then 2 more months of no violations, but he was picked up at that time. And so we're asking the court to consider all the facts and reinstate or set a new bond with reasonable conditions to protect the victim in this case until the case can be heard. We do have depositions set, I believe, September 18th. The trial cycle is in October.
On the original, was the original bond involving grand theft from the
Mother. Yes, sir.
So that's the same person who had the injunction?
Yes,
That's
sir.
correct.
And in that original case where there was a bond, was there no contact? Seemed like that.
I don't believe so,
No
Judge.
contact?
I'd have
No.
to check, Judge, but what I can tell you is, while I do check on that, I'd like the court to know that it's not as simple as him purportedly asking his girlfriend to text his mom about his brother. The text message specifically, I can pull it up on e.com, but it said, he told me to tell you, or I'm paraphrasing, he told me to tell you that he wants to cut his brother's head off and give it to you on a silver platter. These are text messages sent to an elderly woman who's already been victimized by him with the intent of terrorizing her, Judge. And his brother is here too. They're sitting right there on the second row on the left side of this courtroom, and they are afraid for their lives. And they are asking that he continue to be held in jail.
Judge, I believe the law provides my clients entitled to a bond upon reasonable conditions that can protect the victim. Bottom line is, 3 months went by, there was no contact.
That's not a full, the court has a little more.
It does.
The safety of the community is kind of an important issue, maybe the central issue here today. It's not based on the victim only.
I agree, but I don't believe there's any allegations that have anything to do with safety of the community in this issue. I think the state's position would be the victim's afraid. But I believe there's reasonable conditions that can be put in place that are less intrusive than incarceration pending the outcome of this matter. My client doesn't score any Department of Corrections. He's got no prior felony convictions. Court could order a GPS monitor. Additionally, it's my understanding that the alleged victim lives now at Superior Residences. She's in a facility where there's security. I would ask the court to reinstate bond or set a reasonable bond with reasonable conditions, being, for one, if they're concerned about pretrial services with a GPS monitor would be one to
So
put
the
the
bond
court's
is
mind at
on the
ease.
new charge?
No, there is a bond on the new charge, $3,500 cash or professional with pretrial services.
And what was the bond on the other charge?
ROR.
The other charge was ROR?
The original charge was an ROR.
Judge, I'd have to check the record. I was busy looking for the text message so I could read it verbatim to the court. But, yeah, yes, Judge, I would have to check. But if the court would be inclined to hear, the text message says, he told me to tell you that he would cut Dan's head off and bring it to you and say, this is what you did, bitch.
That's what they say is. I mean, I don't have it.
I'm going to deny the motion. You guys need to resolve this if you can. If not, let's go to a trial on it. The court's not going to reinstate bond.
That's all I have before the court, Your Honor. Thank you.
Thank you. Mr. Del Bosa. Bosk. Say it again.
Del Bosk.
Del Bosk.
Good morning, Your Honor. Susan Del Bosk on behalf of LaShamonique Moore. I believe it's 2017-3566. I believe the state has an announcement.
Your Honor, at this time, the state is going to withdraw the violation and his probation will be reinstated.
Very good.
That's
Thank
all
you
I
very
have.
much.
May I be excused?
Yes, ma'am.
Thank you, Your Honor.
Mr. Griffith.
Yes, could we pass them on for?
Sure.
Thank you.
Mr. Nopes? Mr. Nopes here? We'll pass his too.
I did see Mr. Notes earlier, Your Honor, so we should be here sometime.
That's all right. That's all right. We'll pass it. Mr. Madden, is Mr. Madden here? They're talking to the client too. Is Ms. Merrifield here? Okay. Very good. So. Why don't we go ahead and do the no attorneys? Is Mr. Marcus Gonzalez here? Would the state announce on this? You can come up to the podium, sir.
This is Mr. Marcus Gonzalez, case number 22 CF001927. He's here on a violation of probation. If he would like to resolve that today, the state would be willing to extend his probation 6 months to complete the substance abuse evaluation and any recommended treatment, install an ignition airlock on his vehicle, and do the vehicle impound.
Okay. Sir, You have a right in this violation of probation, which is essentially a new charge. You have a right to have an attorney appointed. The state has made an offer, but you have the right to talk with your attorney before you take any action. Do you wish to have an attorney appointed? Or you're here today on essentially this is the first time up, so you have to make a plea, deny or admit. They're making you an offer, but you do have a right to talk to an attorney before you do anything. You're not going to give up any rights. The offer will stay open. Okay. No. We need to get the interpreter here. Okay. You can tell him that we're going to get an interpreter and bring him back up. Okay. Go ahead. Go back now. We'll get an interpreter. Teresa Gore. Should have asked at the beginning. Would the state announce, please?
Yes, Judge, this is Miss Teresa Gordon.
Is that Gore?
Gore.
Oh, Gore, I apologize. Her case numbers are 2019 CF 0000862 and 2022 CF 002928. If she'd like to resolve her cases today, the state would accept 16.2 months in the DOC.
Okay. So, ma'am, you do have a right to have an attorney appointed in this matter. You wish to have an attorney appointed?
Yeah.
We can appoint.
Yeah, because
I'm
I
gonna-
left on medical issues.
Hold on. I'm going to appoint the public defender, and I'm going to go ahead and enter a denial so that we protect your rights. And then we'll come back on this so you can have a chance to talk to your attorney. Just don't say anything at this point. So we'll come back. October 12th, where are we at with our October 12th and 17th numbers?
There's only 2 separate ones.
On the 12th? October 12th, we'll come back. You want to try and bring out Sebastian Orr? He's no attorney. Is he here?
He said more?
Orr, Sebastian Orr. It has him listed as county jail.
I'll show him on our transport list.
Okay, well, I'll just circle that and we'll deal with it at the break. Okay, Mr. Harper, you want to?
Judge, mine are all in custody. I don't know if you want to.
Okay.
I do have a couple out of custody, Your Honor.
Okay. Who wants to go first?
Mr. Gates can go.
Mr. Gates? Okay, hold on a second. Let me, okay, Mr. Gates?
Yes, Your Honor, I'll take Sean Florence.
Okay.
Your Honor, this is Mr. Florence coming down. It's scheduled as a Ferretti hearing. Mr. Florence had filed his own motion essentially stating that I was not representing him.
Correct.
And I wanted to have him come to court and either continue with that hearing or let the court know what he wanted to do.
So, Mr. Florence, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? I do. So where we're at right now, let me just walk through this because I'm going to have to ask you some questions. So, you have an attorney that's been appointed.
Yes, sir.
Okay. You have an absolute right to fire your attorney. Okay? That's everyone's right. You don't have to, nobody's going to force you to have an attorney. But, and it's my understanding that that's what you want to do. So my first question is, are you wanting to fire your attorney?
No, sir.
You don't want to fire your attorney?
No, sir. I would like to keep Mr. Gates.
Okay. So you don't want to do?
No, sir.
Have the hearing for okay, you feel like you've discussed it with him and you feel like he's representing you competently and appropriately at this point?
Yes, sir.
Okay, you sure?
Yes, sir.
Mr. Gates?
Yes, Your Honor. With that said, at this time, I think we'll enter a denial on the VOP if we can, Your Honor.
Very good.
It's 22 CF 2607. It's actually scheduled for next week, but that'll take that off the docket.
Okay.
If we can schedule that for October the 9th, when Mr. Florence is scheduled for pretrial conference.
I think that's October 12th.
Pretrial
Oh, the
conference?
pretrial.
Yes, Your Honor.
Okay. Okay, October 9th. Very good.
Thank you.
Okay. Thank you, sir.
Señor González, venga aquí, por favor. She's gonna be back downstairs.
Good morning, Your Honor.
Good morning. Madam Clerk, would you swear the interpreter?
Please state your full name. Teresa Iribarren. Do you agree to accurately translate from English to Spanish and from Spanish to English the matters brought before the court, so help me God? I do. Thank you.
Okay. This is case number 22 CF 1927. Mr. Gonzalez, you have been charged with a new charge of violation of probation. And this is your first hearing today. And you're here to enter either a denial of the violation or an admission. You do have a right before, however, we proceed with that, you do have the right to have an attorney appointed. Now, the state has made an offer, which you can consider today, or we can enter a denial, and you can have an attorney appointed so you can talk with them. I'm not trying to push you into doing anything today. As a matter of fact, I would be reluctant to do anything today, so you can talk to your attorney. But the state does have an offer. What is your offer?
The offer is we would extend probation.
Slow down,
The-
so she can interpret.
The offer is that we would extend probation by 6 months so that he can attend the substance abuse evaluation and get any recommended treatment, install an ignition airlock onto his vehicle, and complete the vehicle impound.
First of all, does he understand what the state is offering him?
Yes.
And does he want to have an attorney appointed so he can discuss it with him? This offer will not be, this offer will remain. No, it's not going to go away if you want to have an attorney appointed.
Puedo decirlo, apenas que ya había cumplido todas las clases y el
The
día que
thing is, Your Honor, I complied with all of the classes.
me arrestaron el día 16 y yo
And-
mi
and then I
cita
was-
la tenía el 21.
I was
Don't talk-
arrested.
Don't talk about your case. That's why it'd be good to talk with your attorney. Okay.
Está bien, entonces,
Then yes, Your Honor.
So I'm going to appoint your attorney, and I'm going to enter a denial. So who's going to be?
It'd be me, Your Honor, but I'm checking with probation to verify, because if that's the allegation, I want to appointing an attorney if we can get it resolved today without much of an issue, so that's.
Your attorney is checking with probation to see what's going on.
We're checking, Your Honor, it sounds like he has completed all the obligations.
yo tengo los comprobantes.
We can ask probation, Your Honor, but they're saying he's completed all the obligations.
If probation is saying that he's completed all the obligations, then the state will dismiss the VOP.
Does the probation wish to just make sure, confirm that on the record?
Yes, absolutely, Your Honor. From the records that I'm seeing, he's completed all conditions of the supervision.
Very good. Probation has confirmed that you've completed all of your probation items, and therefore this violation of probation is being withdrawn. Now, is he still on probation for a little while longer?
His scheduled termination date is October 9th of this year.
Okay. So you're still on probation, still stay in touch, but you're on track with everything, and probation will end October 9th. But stay in touch with your probation officer. Do you have any questions?
No.
No,
Okay.
sir.
So the court is not appointing the public defender on this case.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Okay, thank you.
Muchas gracias.
Yes, sir. Mr. Griffith, you want to go?
Judge, my client's just pulling into the parking lot.
Can I call my last out of custody real
Sure,
quick?
sure.
Joseph Creech. Your Honor, Mr. Creech.
What about, oh, I'm sorry, go ahead.
All the rest I have are inmates, Your Honor, and except for one that's in custody in another county. Mr. Creech is before the court in 15 CF 2837. He also has 23 CF 1773 on the afternoon docket. At this time, we'll enter a denial in 15 CF 2837 and a not guilty plea in 23 CF 1773.
And you want to come back on pretrial?
Yes, Your Honor.
October 9th?
October 9th.
Okay. Very good. So the court will enter a denial on the VOP and a not guilty on the new law charge this afternoon, and you do not, make sure I get that one. You do not have to come back this afternoon. Okay, very good. Thank you. Mr. Gates, I also have a Tremel Gilbert that
Yeah.
says it's not out of, is that the one that's in,
Yes, Your Honor, the state and I discussed this. Mr. Gilbert is before the court, 23 CF 313.
Okay.
He was picked up on some warrants out of Bay County and is currently in custody over there.
okay?
The plan was to continue his case to October the 9th.
So should we continue to October 9th or another miscellaneous because it's a VOP?
It's not a VOP, it was set for a plea today, Your Honor.
Okay, so we'll continue it till October 9th.
Thank you,
Is
Your Honor.
that good, State? Yes?
Which case was this, Judge?
This is Tremel Gilbert.
Thank you, Judge.
23 CF 313.
Thank you, Judge.
Is that good? You're okay with that?
Yes, Your Honor.
Okay,
Thank you, Your Honor.
very good. Mr. Medina?
Your Honor, Steve Medina with Nathan E. Poole. The state's looking at the agreement I wrote up that had the state's offer for a violation of probation plea agreement in 21 CF 1455.
What is your client's name? Yeah, I'm sorry.
Nathan Poole, Poole, last name.
Your Honor, he was on the end of the docket.
He's on what?
The end of the docket. He was on my page 13 for this morning. It looks like he's 31 on the document.
I think he was an add-on maybe from the original one.
Would you give me the case number? I don't
Yes,
have
Your
it on
Honor,
my
it's
docket. It probably is an add-on.
21 CF 1455.
And he's here on, is it a violation?
Yes, he's here on a violation of probation. And essentially what I did and he signed was a violation of probation agreement to resolve his misdemeanor VOPs that memorialize the state's offer. The one little kink is that there were two misdemeanor VOPs, and the first one, count one, would have expired 11/29 consecutive terms, so that would have expired. So this would be revoke and terminate as to count two. I just want to make sure we're okay, and then I'll provide it to the court.
State?
This appears to be correct, Judge.
Okay.
May I approach, Your Honor?
You may.
And we don't need this one sheet. Thank you. May I approach?
Thank you.
Your Honor, under this agreement, Mr. Poole, the admission is to the VOP as to count two only. The probation, it's agreed, has expired as to count 1. And as to count 2, he was previously adjudicated guilty, as he was on count 1. It would be revoke and terminate supervision, $100 VOP fee, 150 PD fees, outstanding monetary obligations to collections or lien after 6 months.
Mr. Poole, would you raise your right hand, sir?
Yes.
You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you've heard your attorney state the terms of your plea agreement, and I see those same terms are contained in your written plea agreement. You've signed.
Yes, sir.
Have you read this closely and gone over it in detail with your
Yes.
attorney? Make sure you understand what the plea agreement is.
Yes.
Believe it's in your best interest.
Yes.
Based upon that, the court will accept your plea. The court will, as to count 1, the probation has expired. And this is only as to count 2. You'll be previously adjudicated guilty, revoke and terminate the fees and costs, all outstanding obligations, monetary obligations. You'll have 6 months to pay, or it goes to lien in 6 months, after
Yes, sir.
6 months. Okay?
Yes, sir.
Thank you.
Thank you, Your Honor. Okay, good luck. You can take that with you if you want.
Yes, sir.
Thank you. The others are all in custody for me, Your Honor.
Okay. So, who came back in first? Mr. Madden, come on.
We're ready for number 20, Brock.
Good morning, Your Honor.
Good morning.
John Madden here. I've got 2 cases on your docket this morning, Your Honor. The first is out of custody. It's Robert Daniels. He's got 2 cases on your docket.
I only have one of his cases, but so give me the case number.
Yes, sir. Which one do you have?
I have 21 CF 2593, which is a VOP.
So he's got that one, Your Honor, and then he's got a new law, which is 23 CF 565, which I thought we had tracking together. But
Is
we
that going to be on this afternoon by any chance? Is
it
up
may,
for-
Your Honor, but we have reached a resolution on all cases this
Okay.
morning.
Very good. Yeah, it's on. No, there's a Daniels, but it's a different Daniels this afternoon. Okay,
So
that's all right.
it's been executed by all parties, Your Honor. Mr. Daniels is going to be entering a plea of no contest in case number 23 CF 565 to the lesser included offense of sell, manufacture, deliver of cannabis. There's going to be a withhold of adjudication on that case. He's going to be put on probation for 1 year concurrent with the other case, the VOP case. And probation will terminate on May 9th of 2024 if there are no new violations and all terms are completed. There's fines and court costs, $615, $100 cost of prosecution. He's going to complete a substance abuse evaluation and any recommended treatment. Count 2 in 23 CF 565 is going to be dismissed. And then in 21 CF 2593, which is the VOP case, he's going to admit to the violation in that case. We're going to maintain the withhold in that case. $100 violation of probation fee. He's going to be reinstated to probation concurrent with the new the new case. He's going to complete all original terms, and that probation will also terminate on May 9th of 2024 if all his terms are completed and there are no new violations.
State in agreement, would you?
That is the state's agreement.
Yes?
Yes.
Okay.
And Your Honor, we do have a score sheet for you, but we'll give it to you in just a minute. The total sentence points are 38.10, so this is not a down payment.
Very good. Is this a lesser included, the 23 CF 565?
It is.
Yes, sir. The original charge was a sell, manufacture, deliver within 1,000 feet of a school, daycare facility, park, and it's been amended to the lesser included.
Okay. Mr. Mr. Daniels, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay, and as to maybe you said that, you can put your hand down. Maybe I didn't hear you, but on count 2, we just want to make sure and confirm it with the state. Count 2 of 23 CF 565, which is a possession of paraphernalia, that count is being dismissed. Did you say that? If I did, I missed it.
Yes, Your Honor.
Yes, Your Honor.
That's why I generally have these things, looking at them, so I'm tracking them, so I'm have a hard time picking them.
I'll make sure to bring an extra
That's all right.
copy.
I'm a little, you know, I follow these things.
Still on a high note from that Duke game, huh?
So, Mr. Daniels, you heard your attorney state the terms of the plea agreement,
Yes, sir.
and you've signed the written plea agreement. Have you gone over it in detail with your attorney and read this plea agreement?
Yes, sir.
You understand that by entering into this plea agreement, you're waiving the right to go to a trial and contest all these charges. You believe this is in your best interest to do this here today?
Yes, sir.
And you have had all your legal questions answered by your attorney?
Yes.
Very good. Based upon that testimony, the court will accept your plea agreement, and there'll be an amendment to count 1 to a lesser included cell manufacture, delivery, or possession of cannabis, and you will receive a withhold of adjudication on that count. 1, you'll receive 1 year of probation, and it'll run concurrent with the current probation of 21 CF 2593. Probation will terminate on May 9th. If there's no violations or completed, you've got fees and costs. You must complete the substance abuse evaluation and any recommended treatment. Only thing I'd say to you, you need to get on that. And then you're going to run up to the end of it, and they're going to be trying to violate you. You haven't finished that. You haven't finished your, so go ahead and get that like this week, okay?
Yes, sir.
Very good. And then as to the current violation of probation of the current case 21 CF 2593, there'll be continue to withhold the adjudication, fees and costs, complete all the original terms. And again, it'll have a termination of probation on May 9th if everything, if there are no new violations and everything's complete. Any questions? Anything, Mr. Matt?
There is a signature page on the back for Your Honor, in case you didn't see it.
Yeah, I generally don't sign them.
Okay, that's fine. Some
That's all right.
judges do, so I always include it on there.
No, that's good. Okay, thank you.
Thank you, Judge. Your Honor, the next case I have is Brock Hammerstrom. He's got 2 cases on the court's docket, 23 CF 447, 23 CF 389. And we are here this morning on a bond hearing, our motion to establish a bond in this case.
Very good. I've reviewed your bond, but you may proceed.
Thank you, Your Honor. I would, Mr. Hammerstrom's father's here, and I'd like for him to give some testimony to the court.
Okay, if we're giving testimony, we're in the morning sessions. There's supposed to only be a few minutes. If it's a longer hearing, it needs to be scheduled in the afternoon.
I've only got 1 witness, Your Honor, and I apologize. When we set it for today, I didn't realize that there was a
Okay,
morning or
that's
afternoon.
the rule. Short hearings in the morning, long ones in the afternoon.
Yes, sir.
No, I can't get through my morning docket.
I understand. It will be brief, Your Honor, and it's only 1 witness.
Do you wish to call him first?
Yes, sir.
Okay, you can come forward. No. Cannot have the, can't have the.
How old is she?
Cannot.
28. She's 28. She's an adult, Your Honor.
Is that who's testifying?
No, sir. No.
I'm just saying, he was coming up with him.
I think there's some communication issues for her.
I understand that.
What's going
Yeah,
on.
that's what I,
But you
go ahead and come up here to the witness stand. Is she on?
She's 28.
I understand that, but is she okay? Does she understand what's going on? Yes. This is a different situation. I want to make sure she's not uncomfortable being by herself there. Would you raise your right hand, Senator Clerk?
You swear affirm the testimony you're about to give that you have the truth, the whole truth, and nothing but the truth?
Please be seated, sir.
Mr. Hammerstrom, could you state your full name, please?
Yeah.
And Mr. Hammerstrom, where do you live? And how do you know Brock Hammerstrom? And how long has Brock lived in this Okaloosa County? And does he have, besides yourself, does he have other family in the area?
Yes, it's just,
And what's her name?
yes, Grace Emerson.
Okay. And do they live at the home with you? And Grace, does she have any special needs?
Oh, she's Down syndrome.
And prior to his incarceration, did Mr. Hammerstrom help you with Grace?
Yes, mother passed away. I went past this issue. Brock has done incredible help. She's never been violent.
And since he's been incarcerated, has that made it much tougher on you and Grace?
Yeah.
And if Mr. Hammerstrom was granted a bond by the court here today, would he be able to live with you?
Oh, yeah.
And would you be willing to keep track of him, supervise him,
Absolutely.
make sure he completes any conditions that the court
I'll make
issues?
sure, I'll make sure that these obligations are filled with the court, yes.
Tell the court a little bit about what kind of person Brock is.
He's been a great son until he got involved with the drugs, but he took him off track, and he's had a hiccup. He's been a great kid, very, very smart, hard worker, perfect, yeah. He's been a good man.
I don't have any further questions, Your Honor.
I don't have any questions for this witness.
You may step down, sir.
Any other witnesses, Mr. Madden? Are you calling your client or?
No, Your Honor, argument at this point.
You may proceed. Your argument.
Your Honor, Mr. Hammerstrom is being held here on just the BOP cases where he has a no bond currently. The new case, he has been granted a bond in that case. He's got a count one of a hit, leaving the scene of an accident, a $2,000 cash professional, possession of controlled substance, $2,000 cash professional, and a ROR bond on the possession of marijuana. So he was granted a bond by a judge in the new cases. None of those cases involve any violence. He has never been convicted of any crimes of violence. So this is not.
What are the new charges?
The new charges, Your Honor, are leaving the scene of an accident, a possession of controlled substance, and a possession of less than 20 grams of marijuana. None of which have been proven at this point. They're just allegations, and we are
That
very.
would make it the third drug charge, because he's got two drug charges. What is that case number, the new charge?
Judge, the case number is 4623CF001507.
23 CF what?
1507.
Okay. So 23 CF 447 and 23 CF 389 are also possession of controlled substance. So that was my question. So this is the third possession of a controlled substance charge.
That he's been charged with, Your Honor, on both both of the
I understand.
both of the cases he has held on BOP were both pled down to misdemeanors. So he's not on felony probation currently, even though they are CF cases. There were two misdemeanor counts, and the current allegations are that this controlled substance and this marijuana were found in his car. However, he was not in the car. So I think, there are some evidentiary issues to that case, and it's not, the presumption is not great. In that new case that we have, he has been incarcerated since July 6th of this year, Your Honor, so he's been in already for over 90 days. Mr. Hammerstrom does not have any prior failures to appear. He has always made it to all his court dates, regardless of what the charge has been.
And so in your 23 CF 1507, what are the allegations of the possession of controlled substance? What is, you said it was marijuana?
No, so the possession of controlled substance, Your Honor, they don't have listed on the, oh no, I'm sorry, it's fentanyl, Your Honor, is the allegation.
I thought you said marijuana.
He's got a possession of controlled substance, which is the fentanyl, and then he's got a possession of controlled substance less than 20 grams of cannabis. There's 2 different counts.
Okay, and leaving the scene of an accident.
Yes, sir. So 3 counts total. Yes, Your Honor.
Okay. I didn't hear you on possession of control. Maybe you said that, but I actually looked at it and made notes of it that it was a fentanyl charge.
Yes, sir. No,
I didn't hear you say that.
I'm pretty sure I did, but that's fine. I don't mind restating it to the court to make sure everything's clear.
Okay. Are you finished, Mr. Mann? I'm sorry.
Just a few more things, Your Honor. So again, he's had no failures to appear. He has retained counsel. There should be no concern with the court that he will be here for his court dates. Again, he's already been in for 90 days. He's been in for over 90 days at this point in time. As been testified to, he has a place to live. He does have strong family support. They did both, him and his father and his sister showed up here today to show that. He has people to help him stay on the straight and narrow, comply with whatever conditions that the court gives. There are less restrictive means of the court to help with any concerns the court may have. A drug patch could be an option. Weekly pretrial service check-in could be an option. There are ways to monitor Mr. Hammerstrom, and it seems to me that the court is concerned about the drug issue, but I believe there are other ways that can be handled so that he can be out to help his father with his sister and to get in a better place while also being monitored so the court is not concerned about any sort of repeat incident. So what we would be asking the court for is we would like a signature bond or a low cash or professional bond so that Mr. Hammerstrom can get out, help prepare for his defense, help care for his sister. And if the court would want to do a drug patch or, again, weekly pretrial services check-ins instead of monthly, then Mr. Hammerstrom would be agreeable to that.
State.
Judge, let me tell you what happened here. This defendant plowed through someone's front yard and then ran. He left the scene, was found a half mile away at his residence, and when they went into the car, they found fentanyl and marijuana. Judge, I'm not saying that he's violent, but what I am saying is that his addictions have blossomed and morphed into a danger to society because he's driving through people's front yards, taking out property, and with fentanyl in his car. So I believe that his bond should remain exactly where it is because he should remain exactly where he is.
This is your 3rd charge, and it's a serious charge. Court's going to deny the motion to reinstate bond.
I had the same issue.
Thank you.
Thank you. That's all I have, if I may be excused.
You may. Mr. Griffith, I think you were here first, but
Judge,
you want to let?
one of the few times I was early, my client's not quite here yet.
I thought you said he was down in the parking
I
lot.
thought he was, that was what I got from my office, but I'm still waiting for him.
Oh, okay. Ms. Merrifield.
Good morning, Your Honor.
Good morning.
I have one on the docket, James Urquhart. He is an inmate, Judge. Franny Merrifield on behalf of James Urquhart in 23 CF 1734. Mr. Urquhart is present. Judge, we're here today on the motion I filed to reinstate his bond. Did the court have the benefit of reviewing that?
I have.
And Judge, since the previous bonds were released, I did file a motion to reinstate. However, what I'm asking today is for the court to set the bond. As those bonds have been released, there's nothing left to reinstate. So in addition to what I laid out in the motion, I do not have any witnesses to call, Judge. Mr. Urquhart was arrested on 7/31 and released on August the 2nd for 2 offenses. It is with the same listed victim. One was a felony offense, which is domestic battery by strangulation. That's this case. He received a monetary bond with pretrial services. And then there was another case that was filed as a misdemeanor. So he has an additional case for that in 23 MM 2709, which he was placed on bond.
What was the misdemeanor charge?
The misdemeanor was a misdemeanor battery. So essentially at the same time that the felony was reported, an additional allegation of misdemeanor battery was also reported. So rather than it being filed in the same case number, it was separated out. So we have multiple
I'm not following. I was tracking you and now I'm confused.
So
Give me, I need time sequence because.
So when essentially what happened was when the listed victim reported the felony, she made an additional.
Give me the case. You got the domestic battery by strangulation. Did that occur first?
Yes, Judge. So that is listed.
That was charged first and occurred first.
So that is my understanding.
Yes?
That is my understanding, Judge.
Okay,
Is
that's
that
all
was the original case.
Right.
That was provided. And Judge, if you will just bear with me, I don't have discovery on all of these cases because I do have quite a few. So the domestic battery by strangulation.
The state needs to confirm what's going on here, so you need to be paying attention.
I am, Your Honor.
Okay.
So the domestic battery by strangulation, Judge, was alleged by the listed victim. That's this case that we're in front of today, the 23 CF 1734. The date of that offense, according to the information, was May the 28th. It is my understanding that at the same time that that allegation was made, an additional allegation was made for misdemeanor battery involving a different offense. So a misdemeanor case was initiated for that one, and that's 23 MM 2709.
I'm still not following.
So, Your Honor, I think I
Because
can.
the way you phrase yours,
Hopefully
Ms.
provide
Merrifield,
some
the
clarity.
defendant was arrested for violation of pretrial conditions related to a different case. This is intimately interacted. Are they the same matter? Are they different?
So, Your Honor, the state's understanding is actually that the misdemeanor battery occurred on July 31st.
Give me a case number, because both of these are misdemeanors, and they're both batteries, I think.
Judge, the misdemeanor battery is 23 MM 2709. That is the original misdemeanor battery.
Okay.
That case occurred, Your Honor, on, I think it was July 31st, and it's my understanding, just for clarity of the court, I'm sorry, Ms. Merrifield, but that there was a follow-up done once the defendant had been arrested for that domestic violence battery, and at the time of that follow-up, the domestic violence battery by strangulation from a May incident was reported. He was then arrested for that case, and then there was also no contact provisions put in place in both the CF case and the misdemeanor battery case, and then there was a subsequent violation of the no contact provision, which led to him being re-incarcerated and back in jail.
And what were those circumstances of that violation? What was alleged?
Your Honor, it is alleged that he was within 500 feet of the victim. The victim reported that she was at karate with her son, which is my understanding that the son is from another relationship, so I don't think the son is blood to the defendant, but she was at karate with her son, and the defendant was within 500 feet at an auto zone, and it was reported to her that he was within 500 feet of her. That's what's going on. she was,
That's all you got? You don't have any of the circumstances? That sounds like a totally innocuous happenstance of a violation. Is that what you're telling me? That's what I'm hearing.
Your Honor, when I spoke to the victim, and the victim did send me a letter for me to read to the court, the people who own the karate place know the defendant, according to her, because she had been there with her son at karate. They know that there was a no contact order and they were worried about her safety. They saw him within 500 feet of her and were worried about her safety and the safety of her child. That is what was reported to me.
Judge, if I may have the opportunity.
Sure.
It is very confusing in this case because when Mr. Urquhart was arrested for the misdemeanor battery, there was an additional allegation. So essentially, he was arrested on the 31st of July. He goes to first appearance that morning. They issue the no contact order. Here is your bond. Your bond is $1,000 cash or professional, no contact with the victim. He goes to get released that day and is served with another arrest warrant for the felony case. So he stays in jail, has first appearance again the very next morning.
The felony case was what?
That is the one that is before you, Judge. That's the 23 CF 1734.
And
that's the domestic battery by strangulation.
On the same victim?
Yes, Judge. This all involves the same listed victim. So that's part of the confusion, is that he's got pretrial services. He has bonds for both of these cases, a misdemeanor and a felony, but it's the same
But then he
condition.
violates the no contact.
And that's the part that I would like to speak to the court about, because the allegation involves him being present at an auto parts store. This is not just a random auto parts store. It's actually the store that he has frequented. He has had the same spark plug issue. He has a rapport with these people. These people know his car. It is across a major highway. This is on Racetrack Road, where we have a double highway and a median. It is my contention that it's not a willful violation. He went to the location that he knows that he can get assistance. It was on his direction of travel. He didn't go out of his way to seek a location that would be in proximity of the listed victim. He has otherwise not violated the pretrial condition and hasn't had any direct contact with her. He was seen with his hood up, working in his car. Now, it's my understanding that the witnesses that saw him and then alerted the listed victim said he was looking in that direction. Judge, he had his head buried in his car with O'Reilly Auto Parts members assisting him. He doesn't have any criminal history other than this string of incidents that has happened with this listed victim. He is a major, he is a senior commercial pilot, he has military members in support of him today, to include his commanding officer, which I find to be very significant. It is rare that I have a commanding officer willing to stand next to a soldier. His father is here in support, and Judge, I would just request there's a least restrict or a lesser restrictive means for him to be on bond to continue to live while we litigate these matters. Place him on a GPS, an elevated level of pretrial services so that we can track him. And that would be my request to the board.
State.
Your Honor, again, I do have a letter from the victim that I would like to.
You want to provide something? Let's do it.
So, Your Honor, the victim is unable emotionally to be in the courtroom right now. She is working with a therapist to try to be in the same room with the defendant, but she is, I do believe, terrified for her life. And again, I think it is of note that there are people who know that this is the incident that occurred and are in fear for her safety and her son's safety, and that's why they were alerted. That's why she was alerted that he was across the street, and there may be some dispute that whether he was looking for her. I think that the victim would testify that she was told at some point that he was looking for her. But the letter that I received from her that I'll read to the court now is, I would respectfully like to request the court not to allow the defendant to post bond. There's nothing dramatic nor theatrical about this plea. It comes from a place of utter fear for what could happen to me and my son if you allow bond. He stands before you a man with absolutely nothing left to lose, and everyone in his path is a potential target. He does not need a weapon. He is a weapon that has no regard for human life, as he has proven when he stepped over my unconscious body and thought that he had killed me, then left me on the floor, face on the bottom of the toilet, while he threw trash in my face and waterboarded me, while my son banged on the door at the sound of his mother trying to regain consciousness as she lay in her own urine because she had lost all bodily function after he stuck his fingers down her throat. He has strangled me on 3 separate occasions. There are currently some charges pending against him regarding that incident, where my 16-year-old autistic son had to stop him from killing me, and I stand convinced he would have succeeded had my son not woken up at my whimpers as I fought to survive. He has tried to duct tape my face and my head. He has bit me until I bled, bruised me, put me in military holds, smothered and choked me, demeaned me, used psychological torture by asking me things such as, do you really want to know what it's like to be strangled, and controlled me to the point where I was not allowed to lock the door while using the bathroom. There was a time I was scared to leave. Now I am free. I am afraid of the retaliation that he feels towards me, although he sits where he is due to choices he made. No one made these choices for him. The defense would like to talk about his outstanding military career. Perhaps he should have thought about the image he was portraying in contrast to the one who was living behind closed doors, and that his military maneuvers were intended for enemies, not the woman he should have protected from men like himself. And Your Honor, I do think that it is telling that other people know the situation and alerted the victim that he was across the street in violation of the no contact order because they were scared for her and her son. Your Honor, I do think that this is a fairly bad domestic violence battery that we have. It is alleged in the domestic violence battery that he did stick his fingers down her throat, cause her to basically asphyxiate, and then there is a 911 call where he ended up calling the police and saying that he didn't know what was wrong with her, but he alleged, I guess, that she was having a seizure, Your Honor. So this is a fairly bad domestic violence battery, and I am concerned for any contact violation, Your Honor. He, from what I understand, knew that her son does karate there and still chose to go to that auto zone. There's O'Reilly's, there's other auto parts stores that could have helped him in this city. Your Honor, he could have avoided being within 500 feet of anywhere that the victim frequented, should he have chosen to, and he did not choose to do that, Your Honor. So the state is concerned about this violation.
Judge, I do have one final point. I think Ms. Sharpless was correct in the fact that these are allegations. Mr. Urquhart is presumed innocent of all of this, and we need the opportunity to be able to litigate it. That is his right. And I would disagree with her, or with the victim's letter. He has his entire life to lose. He's a major, he's an officer, and he's a pilot. And as the court is well aware, charges like this take your wings. Your career is over, everything is over. He's also a senior commercial pilot for a major entity. His wings are gone just because of the matter of the allegation. So I would disagree with that. Mr. Urquhart stands to lose everything that he has worked his entire life for. He was out for 20 days, Judge, and he did not have any direct contact with her. This was incidental and this was not willful. And I would ask that he be given a monetary bond with a GPS that would provide those assurances to the listed victim.
Well, certainly the court acknowledges that these charges, the defendant is innocent until proven guilty. The court also would state that there are restrictions and no contact orders that are put out on these for very good reason. They're explained very clearly when they're provided. These are two very serious charges. They're not just domestic violence. They're domestic violence by strangulation, very serious. If you did it accidentally, that's on you, sir. I'm denying the motion to reinstate the bond.
And Judge, I provided an e-sign order, or I have a paper copy, which would the court
You can provide it to the court.
I did. Thank you, Judge.
Right this way, sir.
Mr. Noakes.
Morning, Judge.
Morning.
I've got Salvador Vertugen. Judge, I've tried to contact him. He's been present before in the past, although he's been late. I've called the number that I have for him. I've texted the number.
What is today's hearing? What were we doing?
We were going to enter a plea if he was trying to come up with $225.
That's correct, Judge. It was going to be a pay and dismiss kind of a situation. We'd given him several continuances to get the money together. He was in court the last time and told to be here regardless of whether he had the financial issue taken care of. I don't see anybody else in the courtroom.
So what's the state asking for?
Your Honor, just asked for a capias.
Court will issue a capias, Mr. Noakes, if you can get him here, you know, we'll review it today.
If I hear from him, I'll say, hey, I'll find a day and we'll show up.
Okay, thank you.
Judge,
No bond.
then I have Mr. Jeremy Sullivan. He's got 3 cases, Judge. The state and I've agreed to put this on next Thursday, and Ms. Lusko and I have an appointment scheduled for Thursday afternoon to chat on the phone about this case, to resolve it.
Okay. So what is next today? Today is the 12th, so the 19th.
19th, yep. Thank you, Judge.
Very good. September 19th, we'll continue this matter.
So if it isn't resolved on Thursday, will we be set for trial on due process rights? What's happens if we don't get it resolved on Thursday?
If we don't get it resolved, you have the right to go to trial. And will the state be ready to go to trial?
On the 19th?
No. The state, if it's not resolved on the 19th, are we going to be announced ready for trial? We're going to go this cycle?
You know, this is something that the defense attorney and I had talked about last night after 5 o'clock, and I'm happy to tee this one up for a trial. I just don't know if Mr. Nopes has the ability to try it this cycle, though.
Judge, I've already got a previous case set for trial with Judge Brown. It's going this time, which I think is the first and second week of October.
Okay.
And it is definitely going to trial.
But his criminal trials are different than my criminal trials.
Right, I don't know if yours, when's your next?
My civils, his civils are my criminal and vice versa. So mine, let's see when, let's see. Yeah, I mean, the next cycle, October, it'll be in the end of October.
Then
October 23rd and 30th, so.
And to be clear, I want to put on the record, I'm not announcing ready for trial. I'm just saying I'm not opposed to teeing it up to get to a good position by jury review.
Okay. Well, let's try and get it resolved next week. If not, let's get it ready. We're all trying to get these things to trial, so.
We'll get it resolved.
Okay.
Thank you.
By next Thursday.
Sure.
Thank you, Judge.
Thank you. Mr. Harper? Mr. Griffith, are you?
Client's here, Judge.
Okay, well, let's do it. Let's do Mr. Griffith.
Thank you, Judge.
So that'll be Shamal Roach.
That's correct, Judge. Mr. Roach drove down from Kentucky and got in bad weather and got delayed. May I approach?
You may. Thank you. Mr. Griffith, would you please announce the plea agreement?
I will, Your Honor. At this time, Mr. Roach is going to withdraw his previously entered plea of not guilty.
Did you announce the case number?
Oh, I'm sorry,
It's
Judge.
4620 CF 2883.
Okay, go ahead, Mr. Griffith.
At this time, Mr. Roach is prepared to withdraw his previously entered plea of not guilty and enter a plea of nolo contendere to each count of the 3-count information, with the understanding he'll be sentenced pursuant to the sentence recommendation It would be an adjudication of guilt as to each count, 3 years probation at $40 a month cost of supervision. He would pay $515 in court costs. He would forfeit any claim to any of the items seized by law enforcement. He may travel for work. He lives in Kentucky, Your Honor, and may terminate his probation at 18 months if there are no violations and all conditions of his probation have been met. I would ask, however, he did have a cell phone seized by law enforcement, and it's got pictures of his children on it, and he would ask for that to come back. And I don't know if the state would have an objection to that.
We didn't talk about it before now, so I'm not gonna add to the plea agreement.
Okay.
So, one point of clarification, Mr. Griffith.
Yes, sir.
I know the answer to this, but I want to make sure and put it on the record. The 36 months probation, is that for each of the 3 charges running concurrent?
No, sir, that would be for count 1. As to counts 2 and 3, it would be 1 year probation since they're misdemeanors, and they would run concurrent with count 1. I'm sorry, I didn't put that on there.
Thank you. While you're doing that, I'll inquire of your client. Mr. Roach, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of your plea agreement, the discussion, the core of which is the 3 years of probation, plus fees and costs and forfeiture. You understand that? Have you gone over this with your attorney, made sure you had all your legal questions answered?
Yes, sir.
And there's a written plea agreement. Have you read that written plea agreement? Make sure you, because it's got a lot of legal stuff. The big thing is you're waiving the right to go to a trial. You understand that?
Yes, sir.
So you have the right to go to a trial and contest all these things and whatnot. You're waiving those, and this will be a final adjudication of your case. Is that what you want to do here? Do you believe that's in your best interest?
Yes, sir.
You've had all your legal questions answered.
Yes, sir.
Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on all 3 charges. As to count 1, the possession of a firearm, etc. Court's sentencing you to 36 months probation, the number of fees and costs, including cost of supervision, that must be paid during the term of the probation. You'll have to forfeit any claim to any of the items seized by law enforcement, and the defendant may terminate probation at 18 months if there are no violations and all conditions have been met. Okay, the counts 2 and 3, you'll have 1 year of probation for each of those 2. They'll run concurrent at the same time, so it's a total of 3 years. Okay, is that your understanding?
Yes, sir. Thank you.
Okay, very good. Thank you.
And Judge,
Check in with probation, because I know you're up in Kentucky, you gotta figure out how that works. Yes, sir.
With regard to the score sheet, Judge, I don't have one for you today. However, my understanding is the defense doesn't have an objection to the one we produced. So I would just.
Is it a downward departure?
I don't believe so, Judge. This is a 2020 case, so the score sheet is in our system. I'll have to check when I get back to the office, but I don't believe it's a downward departure.
If it is a downward departure by any means, it would be based upon
legitimately negotiated. Thank you.
But you'll get that to me, have to make sure the defense has that. Okay?
thank you, Your Honor.
Mr. Banks, I need your fingerprints real quick.
May I be excused?
You may, sir. Mr. Harper.
Judge, I believe next is Ramaya Custer. She is before the court on 20 CF 1039. If she has not already entered a denial of this violation of probation, we will enter it now. I believe we were appointed on this case last Thursday. I don't have all the documentation. However, I've become aware that there is a case in Crestview, 23 CF 2008. The public defender is still on that particular case. I'm assuming that in that I was appointed on this violation of probation, that I'll probably be appointed to that case, and that it will be transferred to this division. So in view of that, I would like to enter denial on this case and set this for the October pretrial, anticipating that that other case will travel there, and hopefully we'll come to an agreement and resolve it.
So we'll enter denial, and we'll come back on pretrial at 10, actually, 10, not 10, 11, October 11th. For inmates. And either, if it's transferred, obviously, credits be either way. I mean, obviously, we'll run them together, either up there or down here, so whatever.
Yes, sir.
Whatever, which way. You got your client, Mr. Notes? Mr. Harper, can we just jump in real quick on that? Mr. Notes would appreciate it.
If I may approach.
You may. Thank you. Would you announce the plea, Mr. Notes?
Yes, sir. So, Mr. Birchman, in 23 TF 235,
right,
he's going to plead as charged to a third-degree felony. The understanding with the state is that he'll be adjudicated, given credit for time served, $615 in court costs. That includes $100 cost of prosecution, $150 court-appointed legal assistance fee. All of those are payable within 6 months. He's to make restitution of $225 to Kaylee White, and he's got the $225 in cash today, so he's able to go to the clerk's office and pay that. The lady's name is Kaylee White, and
that's spelled K-A-Y-L-E-I-G-H, White.
Right. I'm sure the state has an address.
Speaking to the mic, please.
The address I have for Miss White is 411 Glendale Avenue, Valparaiso, Florida, S32580.
Okay. Mr. Bertubin, I just need to ask you a few questions about your agreement. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay. Okay. So you heard your attorney state the terms of the plea agreement, and those same terms are contained in your plea agreement that still needs the state's signature. State,
I'm sorry.
you got to sign this.
Judge, that's my fault.
That's all right. That's all right. Okay, so you heard your attorney state the terms of your plea agreement, and those same terms are contained on the written plea agreement that I noted that you had signed. Have you reviewed that closely?
I have.
Gone over it in detail with your attorney?
I have.
It's pretty straightforward. You're getting credit for all time served. It's mainly a monetary issue. You've got several fees and costs. The restitution you're going to pay today, right? The $225 to Ms. White. That'll be done today. That's obviously an important part of this. And you'll have 6 months, 180 days to pay the rest of it, or it'll go to a lien. Is that your understanding of what the agreement is?
Yes, sir.
And there will be an adjudication of guilt, so it'll be on your record. Do you understand that?
Yes, sir.
Okay, any questions?
No, sir.
Okay, very good. Thank you very much. Good luck.
Mr. Bertubin, I gotta get fingerprints.
Thank you, Mr. Nose.
And Your Honor, I do have a score sheet for the court that I'll give you a
Okay.
little later.
That'd be great.
Mr. Notes, it's the 33.3 score sheet that we sent to you in discovery.
I thought I had one, but I don't see it.
Thank you.
Thank you, Judge. I appreciate you. And I think I'm supposed to ask you to recall the capias.
Yes, Madam Clerk, if you could recall that capias for Mr. Bertubin.
Thank you so much.
Thank you, Mr. Nose. Mr. Harper, you may,
I think the next one will be Cornelius Donaldson,
correct?
22 CF 1617.
Did you have paper?
Your Honor, if you may approach this.
Of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone
The sidebar discussion with counsel, the court will continue this matter until next Tuesday, the 19th of September. Okay.
The next case, Judge, is Eric Edwards. Mr. Edwards is before the court on 21 CF 2883 and 21 CF 1210. For the reasons that were previously discussed, Judge, we're asking to also bring this back on next Tuesday.
Very good. So the court will continue this matter till next Tuesday, 9/19. Okay?
And the next one, Judge, is Willie King. Judge, Mr. King is before the court on 19 CF 1934, 18 CF 535, and 17 CF 3361. Ms. Bossow and I have been communicating. I think we're very, very close to a resolution, Judge. I think we just need to work out some particulars. If we can bring this also back on next Tuesday, I think we'll be able to resolve this on that date.
That's
Very-
correct, Your Honor.
Very good. The court will continue this till next Tuesday, 9/19, 9 a.m. Okay? Thank you. Thank you. I think that's all yours, isn't it, Mr. Harper?
Thank you, Judge. That's all.
That's all. I'm just going to stand up and stretch for a second. We have.
Are we taking
Either Mr. Medina or Mr. Gates were.
There, they were talking to inmates, Your Honor, but that Mr. Gates should be ready. I think he just went to the restroom.
Okay. Why don't we take literally a 5-minute break? I'm just going to tell him to sit down.
Yes, sir.
I'll be back in 5 minutes.
All right, please.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law.
for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Caitlin Scrivani before the court in 17 CF 1735 and 18 CF 286. At this time, we're going to enter a denial of the violation of probation before the court, and that's the court to continue the case without subpoenas.
Very good. So we'll enter a denial. When do you want to come back, in a month or so?
Yes, Your Honor.
So we'll come back October 12th.
Take care.
Did you get that one, Mr. Lasco?
I did. Thank you, Judge.
Shannon Yuri?
Your Honor, this is Ms. Shannon Yuri before the court. If we can continue her case without subpoenas, I'm working on getting her screened for the Keaton program as a resolution.
Very good. How long do we want to?
Just a 30-day continuous, Your Honor.
Okay. So we'll continue this. Has a denial already been entered?
Yes, Your Honor. It should have been entered on August the 22nd.
Okay, so we'll continue this matter until October 11th.
12th? October the 12th, Your Honor.
I'm sorry, October 12th.
Thank you, Your Honor.
Thank you.
Matthew Ferkel?
What was the name?
This is going to be Matthew Ferkel, Your Honor.
Ferkel, okay.
Yes, Your Honor. 23 CF 902.
Thank you.
Judge, regarding the score sheet, I will send a copy to you after court. However, this is not a downward departure.
Very good, thank you. Would you announce the plea, Mr.?
Yes, Your Honor. Mr. Ferkel is before the court in violation in 23 CF 902. He'll be admitting the violation before the court, adjudicating guilty, revoke and terminate his outstanding probation, sentenced to 8 months in the county jail, concurrent, credit for all time served. Under our cost of prosecution, 150 public defender fee. Mr. Ferkel has asked for 24 months to pay those from the date of release before they're sent to collection.
State?
That's correct.
Mr. Ferkel, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state that in terms of your plea agreement, I see those same terms are contained in the written plea agreement that you've signed. My first question, did you read this?
Yes, sir.
And you go over it closely with your attorney, make
Yes,
sure
sir.
you had all your legal questions. You understand, importantly, you're waiving the right to go to a trial.
Yes, sir.
This will be a final adjudication of your case. Do you believe it's in your best interest to enter into this?
Yes, sir.
Okay. And you have had all your legal questions answered of your attorney?
Yes, sir.
Based upon that, the court will accept your plea. Court will, there'll be an adjudication of guilt. The court will revoke and terminate probation for each of the 3 charges, 3 violations. The court will sentence the defendant to 8 months in the county jail. You will get credit for all time served, and they will be served concurrent. So it's a total of 8 months with credit for time served on each of the cases. You'll have 24 months to pay all the outstanding court costs after you are released. Okay?
Yes, sir.
Any questions?
Yes, sir.
Good luck.
Jeremy Gafford?
Your Honor, this is Mr. Jeremy Gaffer before the court in 05 CF 13, 05 CF 279, and 05 CF 14, all violations of probation before the court. At this time, we'll enter a denial, and that's the court to continue without subpoenas.
So, very good. So we'll come back in October 12th again?
Yes, Your Honor.
Come back for October 12th, continue this matter.
Mr. Davis, can I speak to Judge Kessler for a second?
Not today, but maybe next time, depending on what we do, okay?
Right this way, sir.
Come talk to you.
Jamal Hoover?
Your Honor, this is Mr. Jamal Hoover for the court. He is Before the court today in a violation of probation in 22 CF 1383, but he does have a new law violation set for next week in 23 CF 1929. After reviewing the VOP affidavit along with the original plea, it was determined that the 22 CF 1383 case was past term. He pled to 6 months of probation on a misdemeanor back in August of last year. Clearly, it's been more than 6 months, so that case should be either dismissed or terminated, however the court and the state wants to do that. We do have a plea agreement.
Agree. With regard to which case, Judge? The
22 CF 1383?
I believe he was on misdemeanor probation. I think that it was filed past term, Judge.
Okay, so that should be, so this is the VOP being withdrawn on the,
Can probation confirm that it was filed past termination date? I just want to get that on the record, Judge. Same sort of description.
Referring to case number 22 CF 1383.
correct.
A tentative term date on that was February 7th of 2023.
And the violation report is dated. Making probation work this morning.
I don't see the violation report. I just see that it was listed on the case.
So that may be the issue then, Your Honor, is that there was probably an assumption it was a VOP, which shouldn't have been. So I don't know how the court wants to, if it's just a.
If there's not been a VOP filed, then the court doesn't have to do anything because it's past due, and state certainly, now that they're aware of it, wouldn't be filed.
Yes, Your Honor. How do we want to close the case? That's my only concern. I know Madam Clerk is probably going to say we need.
He was arrested on what? But there was never a VOP filed. So the court, you want me to court direct the clerk to close it because it wasn't properly filed? I mean, it was never filed and it's expired. Court will close it.
Thank you, Your Honor. May I approach with a plea agreement for 23 CF 129, Your Honor?
Sure.
The state will be filing a score sheet later.
Thank you. Would you please announce the plea?
Yes, Your Honor. Mr. Hoover will be pleading no contest as charged in 23 CF 1929. It'll be adjudication of guilt, sentenced to 90 days in the county jail with credit for all time served. Standard court costs, public defender fee. Mr. Hoover's asked for 24 months from the date of release to pay those outstanding costs before they're sent to collections.
Mr. Hoover, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth?
Yes, sir.
So help you God. Okay, so, Mr. Hoover, you heard your attorney state the terms of your plea agreement. And those same terms are contained in your written plea agreement that, let me check, you've signed. And so have you read the plea agreement?
Yes, sir.
You've gone over it in detail with your attorney, make sure you had all your legal questions answered. Importantly, you're understanding you're waiving the right to go to a trial. Contest this will be a final adjudication of your case. You believe that's in your best interest to do that?
Yes, sir.
Based upon that, the court will accept your plea agreement here today. There will be an adjudication of guilt on the charge. You'll be sentenced to 90 days in the county jail. You will get credit for all time served. The fees and court costs are contained in the plea agreement. You'll have 24 months to pay them before they get sent to collections. Any questions?
Thank you. All right, so Mr. Hoover, I gotta get here. Mr. Hoover.
And our next is going to be Andrew Hunter before the court in 23 CF 1480. Andrew Hunter, it's 23 CF 1480.
Okay. We're scheduled for a hearing. The court has reviewed Dr. McDonald's report.
Yes, Your Honor.
So,
The state will be stipulating to their report.
May I approach with an order, Your Honor, for the court?
sure. Thank you. Okay, so the court will adjudicate the defendant incompetent to proceed, commit to the state hospital.
Thank you, Your Honor.
Okay, good luck. Good luck.
Mr. Wilson?
Our last on my docket, I do believe is going to be Mr. Wilson before the court. I had a plea agreement ready to go for Mr. Wilson, which would have resulted in him being released today. However, I was informed that there is a PC warrant for his arrest this morning that will need to be served on him. My expectation is once that's served on him, the VOP will be transferred to Division 2 because his last name is Wilson. At that point, he'll be given another attorney, I do believe Mr. McKinney from the office. So for today, if we can enter a denial and continue without subpoenas, and this will just...
Did you announce the case number?
It's 21 CF 1520.
Very good. The court will enter a denial. Do we need to have a
Just
date?
an abundance of caution, Your Honor, October the 12th, but once that gets open, my anticipation is the VOP will transfer.
Okay, very good. Thank you very much.
And that's all I have for the court. I do want to let the court know, my sentencing at 2:30, I'll let PJ hear.
You want to have Heather
Which one is that? Is that
Darren Taylor, the 2:30.
Okay, got it.
Is actually going to be a plea agreement. So if we can take him earlier, we might be able to, at the 1:30, we can do that, and we might save the court some time this afternoon.
Okay. And if not, we'll do it at the first part of the...
Yes, Your Honor.
But we get in before we will.
Yes, Your Honor.
We're going to do them early too because they birthday and that way we won't.
Mr. Medina.
I'm ready for inmates, Your Honor.
Very good.
Whatever order they come out.
Mr. Hawkins.
This looks like Mr. Cooper.
Okay.
Your Honor, Joshua K. Cooper is before the court in 20 CF 2872. He has a 20-month suspended sentence on a VOP. He's been hoping to get Phoenix House. The state is considering a plea to the bench agreement that it was willing to do, but it wasn't willing to agree to a bars to bed Phoenix House deal at this time. Does the state think we can do a plea to the bench with a 20-month suspended sentence cap, and then we can set it for sentencing?
Your Honor, if we can bring him back in just a few minutes, I will look at that. That request was just made of me, and I haven't had a chance to.
Okay. We'll hold it.
And JJ, we're going to need to keep Josh Cooper there working on it.
Your Honor, Mr. Stanley Crowder, we're ready. We're ready for you. Mr. Deputy Vi, can we get Mr. Crowder to do it? Sure. Your Honor, Steve Medina with Stanley D. Crowder. You all right?
Yes, I'm fine.
Your Honor, Stanley D. Crowder is before the court, 23 CF 639, 23 CF 640, 23 CF 641. He has the agreement that was acceptable to the state. Mrs. Sharpless needs to do the final check. It was the down there, so you said I was filled in the blank for the 2 years and the 3 years for the lengths of the probation that I had at the restitution. So you're going to sign it. No, ma'am, I missed, attempted for 2 of them, so it came down. Your Honor, Mr. Crowder's signing the agreement that we've been over. May I approach, Your
You
Honor?
may. Thank you.
Your Honor, under the agreement that's been signed by the counsel and party, the agreement is there would be an adjudication of guilt as charged in 23 CF 641, and to lesser included offense attempted burglary, unoccupied conveyance, and the statute and the felony level is listed in the agreement in a parenthetical on in both 23 CF 639 and 23 CF 640. So it's as charged as 641, attempted in 639 and 640. 2 years concurrent drug offender probation with special condition of enter and successfully complete Keaton, bars to bed, and he has been accepted at Keaton. Followed by 3 years concurrent regular probation, no trespassing at the addresses of the alleged victims that are listed there. I won't state them unless the court wants me to. No contact with the victims whose names are in the agreement. 515 court costs times 3, 350 public defender fees, and reserved jurisdiction on restitution for 180 days, Your Honor.
That's the agreement with the state.
That is the agreement of the state, Your Honor.
Mr. Crowder, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Crowder, you heard your attorney state the terms of the plea agreement, and I see those same terms are contained. You can put your hand down. In the written plea agreement that you've signed. So, first question, did you read this closely?
Yes, sir.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered?
Yes, sir.
This is a kind of a in-depth plea agreement, and it's got a couple of moving parts. You've got the 2 years drug offender probation, in which you must enter and successfully complete Keaton, bars to bed, followed by 3 years regular probation. That's a total of 5 years. That's going to take a real commitment on your part.
Yeah,
If you violate these, you know what's going to happen. The state's going to come back and ask for prison. So I'm just telling you, you're going to have to get up every morning. It's got to be job number one for you, okay? Because we want you to be successful, but you're going to have to really buckle down in order to get through this. You understand that? You willing to do that?
Yes, sir.
You believe this is in your best interest in order to do this? You understand that by entering this plea agreement, you're waiving the right to go to a trial, other constitutional rights to force the state to prove their case. All that. You're waiving that because you believe this is in your best interest?
Yes, sir.
Okay. Importantly, in the plea agreement, it lists 3 separate, and I'm not going to name their names, call them out, 3 separate victims, 3 separate addresses. Stay away. I mean, you go around those, they'll immediately violate these probations as soon as that happens. Be clear that stay away. Can you do that?
Yes, sir.
I don't know all the circumstances, so I'm not going to, you know them or whatever. You just got to stay away from them. If you bump into him in public, it's up to you to stay away from him. Clear. Any questions about that?
No, sir.
Okay. And then you got your fees and costs that'll be due during the terms of the plea agreement. Any question? Yes.
Yes, Your Honor. I'm sorry. I realize that I neglected to say that this is a downward departure. The defendant does have a lowest permissible sentence of 22.13 months. Your Honor, the state is doing this as an uncoerced legitimate plea bargain. The state does want him to receive the treatment that Keaton provides. So the court is correct that if he comes back here on a violation, the state will be asking for prison. And to remind him, the state did not agree to a suspended sentence, which would act as a cap on incarceration. So he may score, when he comes back, if he comes back on a violation, he is going to score more than 22 months, just so the defendant is aware.
Your Honor, I had one small respectful correction to what Ms. Sharpless just stated. And as I stated, and the court is aware, he's pleading to lesser included offense, attempted burglary of an unoccupied conveyance on in 639 and 640.
Right.
That changes it from a level 4 to a level 3. So there would be a small reduction in points, and therefore an associated small reduction in the lowest permissible prison sentence. He would still score prison. It's still a legitimate uncoerced plea bargain, but I wanted it clear on the record there will be a slight downward adjustment in this final score sheet from the score sheet that he saw.
And the two charges that were they had a downward departure with the attempted burglary, those are still third-degree felonies.
They're third-degree felonies, but they are one level lower.
The 2 years of drug offender probation plus, followed by the 3 years, a total of 5 years. They'll be on each of the 3 counts, but they'll all be served concurrently. Okay, do you understand that?
Yeah.
Okay, any questions?
No, sir.
Good luck.
Billy Balkin, right this way, Mr. Conner, I can get you.
Your Honor, I apologize. The state had given Mr. Balkin a revised offer that was community controlled, but because he has housing issues and for various reasons that's not feasible for him. Is there any way we could bring Mr. Balkin back or hold him over to this afternoon? Because I think he's going to think over a couple of options that I discussed with him.
Very good. We'll carry it over till 1:30.
J.J. Billy Balkin needs to come back.
Right, thank you.
Bobbin?
Your Honor, this is Christopher R. Bobbin before the court in 23 CF 667, 23 CF 657, 21 CF 152, 21 CF 917, and 21 CF 993. Mr. Bobbin has been accepted at Keaton. The state is not willing to do a split sentence with jail followed by Keaton with probation. So that puts him in a difficult situation. The state is willing to agree to some sort of a plea to the bench, but has not made a final decision on a cap. If we don't do an agreement for a plea to the bench, it sounds like the parties aren't going to be able to reach an agreement otherwise, in which case Mr. Bobbin's options are VOP evidentiary, which the state is going to insist on prior to the jury trial on the 2 new fleeing and eluding cases, which of course the court had rescinded and corrected basically the orders. Both those cases are still intact to be prosecuted based on the court's ruling on our motion to dismiss. So, and he understands that, but do you think we can get a cap agreement this afternoon, or should we bring him? Can we hold him to this afternoon, Your Honor? We can at least make hopefully some forward progress. And if we can't,
if you can't do it, just you can announce it, and we'll continue it a week if you need a week to.
Thank you, Your Honor.
We're coming back a week from now.
So you'll be back this afternoon. Thank you, Your Honor.
to see Mr. Taylor.
This is Mr. Daniels.
Your Honor, this is Joshua K. Cooper.
Cooper.
And 20 CF 2872, and just want to make sure that, I mean, you probably haven't had a chance to look.
No, sir, I haven't. I was just confirming that he had a suspended sentence with Mr. Medina just made me aware of.
He reminded me of it, Your Honor. It was put in place when he originally pled out on June 22nd, 2021. And I do not see where it was rescinded. Yeah, and in fact, I know when, at a prior VOP, I think it was Judge Gonteric or Judge Paulson specifically said that the suspended sentence remained in effect.
So what do we need to do for today?
We've got 2 other people held over the afternoon. I don't think it's a super heavy docket on inmates. Could we hold Mr. Cooper to the afternoon? Would that be the best way? Would the court permit that?
Fine.
Okay, hold on. Thank you, Your Honor. Mr. Taylor.
Court security was kind enough to get him up here for us. He's on the 2:30 docket.
Gotcha. You may proceed.
Yes, Your Honor. The state and I had been working on Mr. Taylor's case for the last month. We were able to finally get a resolution worked out. Probation is also on board with this. The only change I need to make is that it's going to be bars to bed for Jada. Other than that, if I can have Mr. Taylor sign the plea agreement.
Hey, Mr. Medina.
Your Honor, may I approach?
You may. Thank you.
There was a plea agreement, the original file completed the court.
Right, I saw that. Would you please announce the new plea agreement?
So to clarify, since one has been filed with the court, do I need to send you another one?
No objection to that score sheet, Your Honor.
Sure.
Great, thank you.
Court will accept the score sheet.
Yes, Your Honor. Mr. Taylor is before the court in 19 CF 2910, 21 CF 250, 22 CF 1746, and 22 CF 2162. He'll be admitting the violations before the court in all 4 cases. He was previously adjudicated. We're going to modify and reinstate his supervision. We're going to add the condition of Jada as a bars to bed. It is a re-entry halfway house program. We also are going to be deleting the intensive outpatient treatment requirement, which was part of the original condition. As the court's aware, that program is no longer around. Instead, we will be doing a substance abuse evaluation to be done at Bridgeway or other place within 60 days of his release, and you recommended the treatment within 90 days of release. Complete original requirements. His probation is not being extended past the term date. That still stays the same. And then standard cost of prosecution and PD fee assessed in each case.
State. That's correct, Judge. Mr. Taylor, would you raise your right hand, sir? Do you swear or affirm affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Taylor, you heard your attorney state the terms of the plea agreement that I see are contained in the written plea agreement that you have signed. So my first question, you can put your hand down. So my first question is, did you read this plea agreement closely?
Yes, Your Honor.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered? You got a lot of legal stuff in the plea agreement.
Yes, Your Honor.
Importantly, it's important that you understand it's in the plea agreement that you're waiving some valuable legal rights. You're waiving the right to go to a trial. You're waiving the right to force the state to prove their case. You believe that's in your best interest to waive those rights? So this will be a final adjudication of this case on these matters.
Yes, Your Honor.
Is that what you want to do here today?
Yes, Your Honor.
And you believe you're entering into it freely and voluntarily? Nobody twisting your arm to get you to enter into this?
No, Your Honor.
Okay. Very good. Based upon that testimony, the court will accept your plea. You were previously adjudicated guilty. The court will modify and reinstate probation on all the cases with the added condition of JADA, Bars to Bed program. Is it going to be at Keaton?
No, JADA is not a rehab program. JADA
Right.
is simply a halfway house reentry
Gotcha.
program. That's why the requirement is to do the substance abuse evaluation through a
Right.
treatment program.
But the Bars to Bed is that it would go directly to the halfway house.
Yes, Your Honor.
Whatever, however
Yes,
it's
Your Honor.
termed. Very good. And so, importantly, as a part of this, you've got to conduct. I mean, we don't want you just to go out, declare victory, and then end up back here later. We want you to be successful, but you got to take some action. Not easy to get this monkey off your back. I'm just telling you straight. A lot of people don't get the monkey off their back, and I'm talking about addiction, dealing with drugs. But it's up to you. We want to give you a chance. We want you to be successful, get back in the community, and be a member. That's where we want to be. We got enough people in Orange.
Thank you.
I mean that. But that means that you got to step up to the plate. You're the one. People will help you, but at the end of the day, it's got to start here. It's not somebody going to give you something. Something you're going to have to start here to get it done. But hopefully, you'll have some support, and people will be able to help you with it. So, as a part of that, you've got to do the substance abuse evaluation as soon as you get out, and within 60 days, and then follow up with the recommended treatment. So, you've got some additional fees and costs that have to be paid during the terms of the probation. So, any questions? Okay, good luck. Probation?
And Mr. Taylor, you still are on community control, so as soon as you're picked up by jail, you need to report to probation to see your officer.
Would the court like to see the inmate from the 130 docket, the felony plea? No, not the 130.
Who do we got here, Mr. Gates?
I have no one else, Your Honor.
I have Mr., that's Mr. James. What are we doing with Daniels?
He's in another institution.
Mr. Medina has Mr. Daniels' case, Your Honor.
Does somebody from the state have Mr. Daniels' case?
Yes, we do. Actually, Mr. Velasco will be getting this case because he's a co-defendant, but I initially had the case. He actually has been he's been indicted, so I believe he's in federal custody.
So what do we need to do on this case?
I mean, I would like for Mr. Medina to be here, but we usually just continue those cases until we find out what's going to happen in the federal system.
Okay, so why don't we do this? We'll wait, make a formal announcement where Mr. Medina is here when we get back at 1:30.
Thank you.
And, Your Honor, I will say the court, there's also Marquand Johnson, who's a co-defendant. He's on the unrepresented docket, same situation. He was in custody of federal authorities.
Now you're talking about, okay.
Yes, Your Honor. Just so the court's aware, he won't be, he was in custody but won't be here as well.
And is he on the 1:30?
Yes, Your Honor.
And who is that?
Marquand Johnson.
I believe they've both been indicted and they did a KPS
Mark-
cross-claim, so they've been.
That's why I mentioned him.
So,
He'll be on the unrepresented docket, Your Honor.
right. So that's number 34 approximately on my docket. So do we need to continue that case?
If the court would like, the court could appoint the public defender's office. Obviously, we'll have to withdraw through the proper channel, but that way we can get that case moving along as well.
Okay.
No objection to that.
Okay, so the court will appoint the public defender.
Yes, Your Honor.
And let's just continue the arraignment on on the next felony plea docket. So that would be,
Your Honor, I think that information's been filed, so we can put those out a little further.
On Mr. Johnson, we'll go ahead and enter a not guilty plea.
you want to enter not guilty? Okay.
Yes, Your Honor. And then Mr. Medina can handle his case either later or when he's back.
Okay, so we'll continue this matter until, you want to just put it on the next cycle?
We can, Your Honor.
10, 11, is that too soon?
It's up to the state.
10, 11?
No objection to 11's fine with me.
Okay, that's fine.
And if we could set both cases, since I'm gonna have both cases, that would be helpful.
We gotta wait for Mr. Medina.
Oh, right.
Okay, so we'll do that when we get back. Just remind me. So when we come back, we'll start off with Daniels this afternoon at 1:30.
Yeah.
Okay. Yes.
I still show Ms. Ramaya Custer on the VOP. That's one of Mr. Medina's.
Ms.
You
Custer
didn't
was
have that?
actually with Regional Counsel now.
Okay, I'm sorry, I didn't catch it when you did that. So, because she has a new case at the north end, so we'll be transferring that out there.
Okay. So do we need to do anything on that?
If you've already handled it, Mr. Parker.
Rudy Parker.
Yeah, that's what I thought. Okay. So we've got a couple that are coming back at the 1:30, and then so we'll start at 1:30.
I just have one last